Hello and welcome to our continuing 2017 educational webinar series. I am Dr. Jill Brooks, Senior Director of Education for First Healthcare Compliance. At First Healthcare Compliance, we help you with a comprehensive compliance management solution tailored to your business, a hospital network, healthcare practice of any size, billing company, or skilled nursing facility. As part of our complimentary educational webinar series, we bring you experts from around the country to discuss relevant topics in the healthcare industry. Our focus this month is on regulatory compliance, ethics, and reputation. We are so pleased to have Kevin Fairlie of Fairlie Law discussing ethics and regulatory compliance. Kevin is the founding member of the firm where he practices in the areas of healthcare regulatory compliance, general healthcare counsel, corporate and transactional law with a special emphasis on the representation of EMS providers and agencies. He has represented healthcare clients and organizations across the country. He has served as counsel for numerous organizations undergoing both state and federal investigations involving state Medicaid investigation units, state attorneys general office investigations, and the U.S. Department of Justice investigations involving Medicare fraud and abuse, False Claims Act, whistleblower, anti-kickback laws, antitrust issues, and allegations. From 2004 to 2014, he led the healthcare merger and acquisition activity for a private equity firm in St. Louis, which required him to serve as president of several healthcare corporations for the firm from 2010 to 2014. Mr. Fairlie currently serves as general counsel and chief compliance officer to several health centers in the St. Louis area. Because Kevin has served both as CEO and general counsel to major corporations, he brings a unique perspective to his clients and understands the many decisions executives must balance in deciding the pros and cons of pursuing various legal and compliance strategies. Go ahead, Kevin.
Thanks, Dr. Brooks. I didn't realize I gave you that big of a mouthful, but I appreciate the introduction. So we're going to talk about some current trends in ethics and regulatory compliance. And I took this from a point of view, I wanted to tie in investigations and how to handle investigations. You know, let's face it, of course we all have compliance programs because we want to do the right thing. We also have compliance programs to avoid getting in trouble. So I want to talk first about how to handle investigations and some of the sorts of things that might pop up with investigations. Just a quick overview. I'm sure everyone on the webinar is already familiar with these entities, but you know, these are the type of folks that are going to come in, and if there are issues, they're going to investigate. They're the ones that are going to be looking at your compliance programs. Of course, the Department of Health and Human Services. Underneath that is the Office of Inspector General, OIG, which we all are familiar with. The Office of Civil Rights, that's the entity that's tasked with enforcing HIPAA. I'm not going to talk much, I don't think at all, about HIPAA today, but they are doing more investigations, more random audits in the HIPAA world. So that's something to be familiar with. If you have somebody show up at your place and they've got a card that says Office of Civil Rights Investigator, it's probably a HIPAA issue. The DOJ, the Department of Justice, those are the folks that would work hand in hand with the OIG and some of these other investigators. You know, that would be your local U.S. Attorney's Office and the assistant U.S. attorneys under that. And also to a greater extent, the state Medicaid fraud units. I believe every state now has their own Medicaid fraud enforcement unit. So those folks may show up at your door, and to a lesser extent, state or local law enforcement. These are some of the current enforcement trends that we're going to discuss today. The Medicare 60-day repayment rule, folks are probably starting to hear more and more about that. It went into effect in February of last year. And as a part of the 60-day rule, they kind of go hand in hand, more emphasis on something called reverse false claims that I will talk more about. We're also seeing more and more of the especially from the U.S. Attorney's Office, the criminal side of those offices getting involved with these investigations and prosecutions. Definitely, I've seen this a lot in my practice, an increased use of data analytics. For so many years, a lot of investigations were driven by complaints, whistleblowers, disgruntled employees. That certainly is still the case, but the feds and even on the state level have really invested into IT capabilities and data analytics. So they look for things that are kind of out of the norm, and then they'll investigate those. And as I mentioned, also increase on the state level with the Medicaid Audit and Compliance divisions. So this is just an example of what I'm seeing, what we're all seeing in terms of greater emphasis on the criminal side of things. Just last month, the U.S. Attorney in Chicago announced that they were creating a new unit dedicated just to the prosecution of criminal healthcare fraud violations. They added 5 new individuals, 5 new attorneys, which is pretty substantial for those offices. And so we're definitely seeing more coordination between these. It used to be primarily if we were dealing with a healthcare fraud issue, it would usually be the U.S. Attorney, the Assistant U.S. Attorney that operated on the civil side of the office. I can say, and I probably have currently about 10 different clients that are undergoing an investigation by a U.S. Attorney's Office. In every single one of those meetings, they have had both the criminal U.S. Attorney and the civil U.S. Attorney in those meetings. That's new. That didn't used to happen. And so as I mentioned, Medicaid is really ramped up as well, and a lot of that is due to an increased pressure from the feds for Medicaid at the state level to get more involved with finding, detecting fraud. We're seeing more and more collaboration with the Medicaid folks and the feds working together more. And in the past year or so, I definitely have heard more from the feds saying, okay, make sure you're looking at this from a Medicare perspective. Your clients need to make sure they're also dealing with this at the Medicaid, at the state, local level. And there's more and more sophistication on the state level. I always say that Medicaid, you definitely need to take it seriously. It's not, doesn't raise the same concerns that Medicare does in a lot of ways. They're just smaller and they don't have the same amount of funds, but we're seeing more and more investigations at the Medicaid level. And these Medicaid fraud units, they have all the same ability to come in and investigate, to apply false claims, anti-kickback, all those sorts of things. They have, it's still healthcare, it's still federal healthcare dollars, so you definitely need to take Medicaid seriously. So I want to talk a little bit about what do you do if an investigator shows up at your door. I see very often folks that have good compliance programs. They know what they're doing, but when an investigator shows up, they aren't prepared for that piece of it. Investigators, the OIG, FBI, the Medicaid folks, they can just show up at your office, talk to folks. Sometimes they'll call and say that they want to have a telephone conversation. I've had cases where an investigator showed up at an employee's house over the weekend when they're out mowing the lawn and start asking them questions. And of course, they're always going to say who they are. They'll have a card and probably a badge and say, tell them they'll say what they're there for and what kind of information they want. And they're usually very, very friendly as well. And it's their goal to get people talking. So you need to make sure that your organization is educated all the way down to the lowest levels, because these investigators often like to talk to folks at the lowest levels. So your employees need to know what to do when those investigators show up. And of course, you don't really want those employees talking to the investigators until they notify a compliance officer, until they notify CEO, in-house attorney, if you happen to have one. It doesn't, there's no hard and fast rule there. It kind of depends on the size of your organization, but you want any such contact being directed to a certain individual who knows how to handle these things. And if you happen to be that person, if you're the executive director or you're the compliance officer, physician that runs the practice, whatever that case may be, you really don't want to talk to these individuals either. And I always say you want to be polite, cooperative, but you should tell them, and this seems self-serving for me, but trust me, it's important, to say it's your company policy, it's your board of directors policy, whatever it may be, that you direct any such communication initially to your attorney or outside counsel, in-house general counsel, again, whatever that case may be. You don't want to start talking until you know exactly what it is that they're there to talk about. And let's face it, they're not going to just show up at your door randomly hoping to find something. If they show up there, they think that they already have information on you. So that's a critical first step for your attorney to take, is to contact these individuals and say, hey, what is it that you're looking for? And they will typically, they'll tell the attorney generally what the issue might be. Again, by the time they show up at your door, they probably know more about your situation than you do at that given time. They have access to records. They've already looked at things. They think that they have a good case, and that's why they're at your door. Once you have an idea of what the situation is, you've got to launch an aggressive internal investigation. You've got to find out if there's anything to it. If it's billing related, you're likely going to want to do some sort of third-party billing audit. If you have a really good internal billing department that you trust, you're going to want them to do an audit and find out what exactly is there. The other thing most likely you're going to do is interview any of the employees that might know something about this situation, because as this moves forward, the OIG, any of the investigators are certainly going to be interviewing or asking to interview your employees. And why it's critical to investigate and really wrap your head around what's going on is that internal investigation is going to drive your strategy in terms of how you respond to something. If it turns out that you've got an employee that left, a disgruntled employee, and you find out that person was intentionally miscoding claims, something that's clearly fraud oriented, then you may want to go through a self-disclosure process that we'll talk about. if you do the investigation and you determine, look, there was definitely no intent, no fraud here, you very likely still have the 60-day rule that we'll talk about, which is not as serious, but you're going to have to determine whether there's overpayments and that sort of thing. And then really, depending on your investigation, sometimes it makes sense to be very cooperative and forthcoming. Other times you're going to want to slow play it a little bit more, and that all depends on the internal investigation. So you really need to think ahead. If you haven't yet, think about what happens if somebody shows up at your door next week. Will your employees know what to do? Will they know who to direct those people to? And if you're the person they end up with, what's your response going to be? Now, sometimes these investigators will show up prior to a subpoena. That's definitely the case for a lot of my clients here recently. They haven't gotten to a subpoena level yet, and we hope that they don't. Oftentimes, the very first communication that you get is they show up with their subpoena. And this is just an example of one. If you get a subpoena that has United States of America, the Office of OIG, and you read through it and it says they're conducting an investigation into possible fraud, you obviously want to take that very seriously. And it seems obvious, although I'll say with one of my clients, it was a health center, again, large, sophisticated. They had a compliance department. They got a subpoena just like this, and came to me at the last minute, had all the documents gathered, and said, "Hey, we just want to make sure you're okay with us sending off the information in this subpoena." And they essentially handled it just like any subpoena from any attorney for medical records. That's definitely not the way that you handle these sort of subpoenas. You want to know every single detail that's in those documents before they go out the door, because the OIG is expecting to find certain things in those documents, and you want to know to the smallest detail what's in those documents before they go out. So a couple of the things that are new and going on in this area is the OIG self-disclosure. This is not entirely new. There's always been a self-disclosure process. The citation here will take you to the actual document. I think it's about a 20-page document that sets out the exact procedure for going through a self-disclosure process. It's much more than just calling up the OIG and saying, "Hey, we think we found an issue of overbilling of $100,000 and we want to send that money back." There's certain audit processes that you have to go through, and it's very detailed. So it would make sense to be familiar with this document. It's not used in all cases. Again, one of the things that's required for the self-disclosure is you have to have some admission of wrongdoing. So it's certainly used in cases of where you think that there's some serious underlying issues. The reason for doing a self-disclosure is if you follow the proper procedures, then it allows you to avoid fines and penalties that go along with the False Claims Act, which is typically what's involved here. And you can get triple damages, and the fines and the penalties add up very quickly. So if you've got a serious issue, you want to avoid those if possible. So the 60-day rule it came out again in February of last year, and essentially what the 60-day rule says, and in a nutshell is if you know or should have known that there might be a potential overpayment that you've received, then you have a duty to investigate and try and determine what that overpayment is. And once you determine what that overpayment is, you're required to make arrangements to pay that money back within 60 days. The name is a little bit of a misnomer. It really is not that you have to return payment in 60 days. The 60-day portion of that is once you've made a determination, once you've identified the overpayments, then you have 60 days to make arrangements to pay that back. And I'll detail that a little bit more in a couple more slides. I have a link down here to U.S.Attorney Bulletin that came out at the end of last year, and it is an overview of how the False Claims Act can be implicated by not complying with the 60-day rule. There's a citation there, but I'm going to talk about that a little bit more here in the next couple slides. One of the other things that came out of the 60-day rule is initially in the draft, it was if you've identified the overpayments, if you know that there are overpayments, then you're required to make arrangements to pay this money back. Well, the feds realize that they don't want people just taking the stick your head in the sand approach, where you say, look, I'm not going to do any internal audits. Why would I audit things just to find out I've got issues to pay it back with this rule that's implicated? So they added language saying that reasonable diligence is required, and added the not only known but should have known. And specifically in the rule, it says that there should be proactive compliance activities on the part of any Medicare provider. So, for instance, if Medicare does an audit and finds out that you've been overbilling for the past 5 years, they come in and do an investigation, and you haven't had any sort of compliance program in place, you don't have any sort of auditing procedures to try and identify these things, they can say that you have violated the Medicare's rule for returning overpayments because you should have known through basic compliance activities that you were improperly billing. So the head in the sand approach won't work. And really what this rule does is says that, to me, every single entity must have some sort of compliance program. It's really not just an option or a best practice anymore. And the real kicker for the 60-day rule is something that's called reverse false claims. And of course, under the Federal False Claim Act, if you intentionally submit claims that are false, you can be liable for civil and criminal liability, federal liability. The reverse false claim is if you've received overpayment, although you didn't intentionally submit false claims, you didn't intentionally miscode, but you receive these overpayments and you are generally aware that you potentially received overpayments and you don't do anything to repay the money, that is a reverse false claim under the False Claims Act. And the citation I gave a couple slides ago is from a U.S. attorney. It happens actually to be the assistant U.S. attorney out of Kansas City. I'm based out of St. Louis, so it's a U.S. attorney that I know. She wrote the guidance to all the U.S. attorneys around the country on how they can use the Medicare 60-day rule and reverse false claims to prosecute individuals that receive money, don't do anything, don't follow the 60-day rule, and don't make an effort to pay that money back, that they can come after you for false claims. So Medicare 60-day rule is very serious, and you really need to be looking at whether or not you're doing audits, what sort of procedures do you have in place to catch issues, especially on the billing side, before they move forward. So now I want to switch gears and talk about the guidance that came out from the Department of Justice earlier this year, and it's guidance to the U.S. attorneys, to the Department of Justice, on how they should evaluate corporate compliance programs if they go in to do an investigation, if for whatever reason they're looking at a healthcare entity. It's information to them on how they evaluate those compliance programs. This slide has an overview of the guidance on this. The document itself is lengthy. There's several different sections with questions underneath each section, and we'll go into some of those here in the next few slides. It's not exactly new information. It's a lot of the same things that we know if you're involved in healthcare compliance. It doesn't change really what compliance programs, how they should be structured, and the key elements of compliance programs. However, I find it extremely useful because there are very specific questions in terms of what sort of things are they going to be looking for, and what do they view as serious and important portions of a compliance program. So I'm going to go over the guidance breaks down different areas of compliance programs, and then in these slides I have certain questions that are straight out of the document, and then I'll provide you with a citation to the document towards the end of the slides. The first thing that they're going to look at, especially if they've come in and they've got an issue, let's say that they think that you've been upcoding a certain procedure for several years, they're going to want to ask, what does your compliance program have in place in terms of finding a root cause analysis? Have you done anything, any sort of audits that may have identified this issue earlier on? Were there prior opportunities to detect the misconduct? Again, audit reports. What sort of controls were in place to identify these issues? One thing that jumps out to me as an example here possibly is, of course, there's always a focus on billing and whether or not you're billing appropriately. Another area that the feds are spending more and more time on is, especially in the not-for-profit, obviously the not-for-profit world, is grants and federal healthcare grants. And you have to comply with all the requirements of those grants. If you're getting federal dollars, you have to spend the money as you indicated that you would. I find that a lot of folks within their compliance programs tend to not think about grants and how are we monitoring, how are we checking to ensure that we're spending money the way that we are. And so that's an example of one of the things that they would look at here. If this is a shock to you that we're in here looking at grant compliance, where were your controls ahead of time to make sure that you were complying? I think that this one may be the most important. It's certainly the one that that I preach, and in my own practice, I've seen over and over. Again, I was in private equity for around 10 years. We would go in and buy troubled healthcare companies, usually with compliance issues, and have to go in and clean up all those compliance problems and get the company turned around. It almost always was a result of especially senior and middle management not being interested or invested in compliance programs. Not that they necessarily wanted to do something illegal. Actually, in most cases, that wasn't the case. It's just it didn't really want to be bothered with it. It didn't want it to be a focus. So these guys, the investigators, the U.S. attorneys, they're going to want to know, you know, the phrase, what was the tone at the top? And they're going to figure that out not by talking initially with executives or upper management. They're going to talk to the lowest level folks, and they're going to want to know. They're going to get their impression. Okay, what did the CEO or what did the medical director, what did you hear from them in terms of compliance and ethics? What's your impression of them? Do you get the impression that they're just all about the bottom line and the dollar? Those are the sorts of questions that they're going to ask folks and start to build a case, especially if this is something that's moving towards some sort of prosecution. They're not interested in the lower level folks. They're going to build a case for the highest level folks. So if you're having trouble, if you're in the compliance world in your organization, and you do have trouble with getting the CEO or higher level folks, the board of directors, really vested in compliance, I would take this section out of this compliance guidance, and these are specific questions that the DOJ says they're going to look at in terms of your organization. So that's pretty powerful if you can take this to the CEO or the board and put it in front of them and say, you know, how do you guys answer this question? So they also, and along the same lines as the upper level management, senior management, they're going to ask questions to see what sort of authority did the compliance program have. What sort of, is there a compliance officer? If so, is the compliance officer someone who is the practice manager who is already completely maxed out in terms of bandwidth, and you just said, hey, you're also responsible for compliance? You know, they're going to want to dig into how much authority the compliance department has, the compliance officer, what sort of stature within the company do they have, what sort of autonomy. If there's a board of directors, does the CEO or the board ever invite the compliance department in to do presentations? If the compliance officer wants a meeting in front of the board of directors, is that person going to be allowed to do that? That's going to certainly be a focus of the DOJ. And again, these questions are not going to be answered by them going to the CEO and having the CEO tell them what their opinion is. They're going to start at the lower levels and find out what the true answers are. Again, with the autonomy and resources, you know, empowerment, funding is also a focus. And again, as they said in the introduction, this all depends on the size of the organization. There are lots of factors to weigh there. If it's a small physician practice, you know, it probably is not reasonable that they're going to go out and hire a full-time compliance officer that's, let's say, an attorney, a JD, and pay that person a ton of money. That's just not reasonable. But you have to take into account the size of your organization and certainly give it the attention that it needs so that that office is effective. Another thing that they do mention in this guidance is if you're outsourcing compliance functions, which is acceptable, they're just going to ask the same sorts of questions. You know, why did you outsource the compliance function? You know, if you have a compliance consulting company, what was your reasoning for hiring that company? And to me, what they're really getting down to is, did you just try and, you know, push this off on somebody else so you could check the box? Or let's say again that you're a smaller or medium-sized organization, it doesn't make sense. You're not going to have the skill set within your organization, and so you went out and found a reasonable, reputable outside organization that will actually move you further down the road towards compliance. That's the sort of thing that they would want to find. So if you're outsourcing any of those functions, you want to be able to demonstrate that you've gone out and found an organization that truly makes sense for your entity. Of course, policies and procedures, it's always going to be a key portion of a compliance program. I think everyone's familiar with policies and procedures and their importance. Again, I think some of these questions are very helpful and very powerful, especially if maybe you're dealing with leadership that doesn't want to spend the time and effort on some of these policies and procedures. It clearly can be time consuming to create policies and procedures to make sure that they're well done and that they make sense. So they're going to ask questions about, you know, who's involved in creating the policies and procedures, and once they're created, what sort of impact, what sort of authority do they have? They're not really going to care if you have a compliance department and a compliance officer that writes the best, thorough, most well-done policies and procedures. If that person sits in an office and does those and then puts them in a shelf in a filing cabinet and nobody else in the organization sees it, you know, except maybe at new employee orientation, those aren't going to be effective policies and procedures. So they're going to want to look at along the management chain, who has input in those, what's the approval process, once new policies and procedures are approved, then how are they implemented? Those are all sorts of the questions that they're going to look for. So it's certainly good to have policies and procedures, but you want to make sure that they have some teeth to them. Training and communications tied in with the policies and procedures. It doesn't really matter if you have wonderful compliance policies, if you have, you know, a beautifully written code of conduct, if nobody in the organization knows about those. So training is absolutely essential. And again, it varies based on the size of the organization. You know, they're going to ask questions like, is it in-person training? Is it online training? If it's online training, you know, what's the content? How effective is it? And again, in my experience, they're going to get these questions answered by talking to the lower level employees. You know, they might, for instance, going back to an initial investigation, if they show up and just start asking your employees, start talking to them, and they have a specific issue that they're looking at. So maybe it's a coding of, a certain type of coding. They'll ask the employee, what's your company's, what's your organization's policy on that? And if the employee can answer that, they're going to ask, well, how do you know that? Do you have access to policies? Are you trained on that? How are you updated on those? Those are all the sorts of questions that they're going to ask. Another absolutely critical element of compliance program is the reporting mechanism. If your company doesn't have a confidential compliance hotline, an outside 1-800 compliance hotline, I think you need to go out today and get one of those. There are lots of options out there. They're very reasonably priced. It's not a major financial investment, and you hope that it's effective. You hope that employees will use it and report issues before they get too big. If nothing else, it's a safeguard for you. If you have a compliance hotline and you promote it and employees know about it, now, of course, I always, in my role in compliance with organizations, I always say, please come to me first. I'll handle it confidentially. But not all organizations have that option. So you definitely want employees to have the option to report somewhere. And if I'm defending an organization against an allegation and that organization has a compliance hotline, that's definitely something I'm going to be pointing to say, hey, we made every opportunity available for employees to communicate this. Why didn't they go through the hotline? Why did they come to you first, you, the investigators? That's a very powerful thing to be able to point to. And let's face it, it somewhat discredits an employee that's making allegations when they didn't go through channels that you had available to them. Incentives and disciplinary measures, these are true for compliance. They're true for really every sort of policy and procedure you would have within your organization, whether it be human resources, employment issues. They're going to want to see what sort of recourse is there for employees that don't follow your policies and procedures. Again, it doesn't help to have policies and procedures if there's nothing to those. And incredibly important thing, and I preach this all the time, is consistent application. Everyone, management, executives, everyone needs to know what the policies and procedures are. They should know what the repercussions for not following those are, and they should be applied consistently across the board. And talked about audit quite a bit. It's really just it's essential that you have some sort of auditing, some sort of control testing. Again, depending on your size, maybe you have a large billing department that's run by some really talented people. It's fine to do internal audits, but you should be auditing and looking for issues on a regular basis. If you're a smaller organization, you can do an annual outside audit for not a whole lot of money, for a few $1,000s. I certainly think that that's well worth it to identify issues and correct issues before they turn into big problems. Another word of caution, though, and I see this quite a bit, is people actually go to the expense of doing audits. They get the audit information back, and they really don't do anything with it. Maybe they send out the results of the audits to physicians, but with no real instruction on, okay, these are the issues that we found, this is what we think we need to correct, and this is how we're going to correct it. Frankly, you're better off not doing an audit than doing an audit and finding issues and not doing anything about it. So certainly keep that in mind. This is just one other issue, somewhat kind of off the side here, but something that a lot of organizations overlook. And you should be aware of your insurance coverage. Again, going back to an investigation, if someone shows up at your door, certainly if you get a subpoena, subpoenas, that can be very costly in terms of just getting outside attorneys involved. Again, I would recommend never turning over information related to a DOJ subpoena without knowing every single detail that's in there. That often means going through thousands of pages of emails, sometimes hundreds of thousands of pages of emails. And so corporate insurance policies will often, especially directors and officers, sometimes it's under employment practices, liability. There will be coverage for the defense costs of dealing with an investigation. Now, they'll rarely, I'm not sure I've ever seen one that covers any fines and penalties that might come out of an investigation, but they often will cover the expense of defending yourself in an investigation, which can add up pretty quickly. So I would recommend, if you haven't, or if you're, maybe someone else in your organization handles insurance, check with them and just ask your insurance broker or whoever handles your insurance to say, hey, if we have an investigation into healthcare regulations, are we covered for defense costs? So just to wrap up, real quickly, in a nutshell, these compliance, the whole purpose of compliance is to catch issues before they come too big. You're going to have to do that really through some sort of auditing, certainly audit of your billing. If you haven't in some time looked at your policies and procedures, go back and make sure that they're up to date. In terms of training, you need to ask yourself, well, how well do my employees know these policies? Ask yourself, hey, if an investigator showed up and started talking to my employees this afternoon, what are they going to tell them about what they know in terms of your compliance policies and procedures? Certainly document everything. Document your audit results, document what you did in response to audit results. If you have disciplinary issues as a result of compliance issues, document that, document what you did so that you have a paper trail. Because, trust me, employees turn over, people come and go. You need to be able to go to some sort of file and pull up exactly what happened. Because a lot of these investigations, they might be looking back certainly 2, often 5, 6 years in the past. So you need to be able to find your document trail. And finally, this is the link to the compliance guidance that I discussed. It's much lengthier. I hit on some of the key elements, not enough time to do it all in one presentation, but it's pretty straightforward. It's just questions under each section that you can look at and help evaluate your own compliance program. And that wraps it up, Dr. Brooks. Trying to see timing. Oh, good.
Yeah.
Got about 10 minutes.
Yep, and we do have a couple of questions. So regarding Medicaid fraud, what would they be specifically looking at? Claims? If so, what types of coding signals a fraud instance?
Well, they would be looking at any of your claims. it just would be the claims, obviously, that went to Medicaid. So I'm not aware of any specific types of claims that they are looking at. It really depends on your industry, but you know, Medicaid goes to the state Medicaid payer or maybe a Medicaid managed care plan, and they have the authority to investigate Medicaid fraud or improper billing on the Medicaid level, just as the feds do on the Medicare level.
Are the audit and compliance issues directed only at Medicare and Medicaid, or can an audit dive into our commercial payers as well?
Commercial is really an entirely different boat. The same, you know, the healthcare laws like the False Claims Act and that sort of thing, those are all designed to protect taxpayer dollars and to protect federally funded programs. So commercial payers are really entirely different. Although you do need to keep in mind, and sometimes it gets a little bit blurry, is this truly a commercial payer, or is this a Medicaid or Medicare contracted managed care plan? And so I would sort that out, and it's the Medicare or Medicaid contracted plans, obviously more of the healthcare laws apply to those folks. But if it's purely commercial, that really gets down to more of the state law, you know, just general contract law, what's in your contract with those folks. You know, so you don't want to ignore any investigations from those individuals, but it's certainly, you don't have the same issues as you would with federal payers.
Is there a standard for the number of billing audits the government views as reasonable, and commenting on in-house versus a third-party audit?
There really isn't. I have not seen guidance on, you know, say the size of your practice and what any sort of recommendation on the number of audits, whether it's in-house or it's outside. It really, so I have smaller clients that do just one audit per year. It really depends on the size. I will say that my impression is, from an investigator standpoint, let's say you did an audit just annually, but in that audit you identified some serious issues. Well, you're going to implement, say, some changes. You know, maybe it's internal training for your billing department. I'm not going to want to wait another year to audit that to see whether our changes are making a difference. So if you're identifying problems, then I would recommend auditing more frequently. But there really, frankly, is not a hard and fast rule on the number of audits. In terms of defending folks, it's always nice to be able to say that someone, that your client conducts an independent third-party audit. That's really helpful. You know, so I guess really I would recommend, at least on an annual basis, hiring some third party to conduct an independent audit for you.
Is there a difference between self-disclosure to Medicare and the requirement to repay under the 60-day rule? Yes, there is, because, and I probably didn't hit on that quite as much as I should have, so I'm glad you got that question. Under the 60-day rule, if you through an audit, or, well, really through an audit, if you find out that you have received an improper payment, you know, maybe it was just
maybe it was an error on Medicare's part where they sent you a wrong amount. And there's really no underlying intent, there's no negligence, there's nothing like that. You certainly have to repay the money, but you're not going to go through the Department of Justice, through the OIG. That's really just a standard repayment with your Medicare contractor or your Medicaid contractor. You're going to contact those folks and just say, hey, we've got an overpayment issue. We'll send you a check or take it out of our, out of our deposits going forward. So in a lot of cases with Medicare's 60-day rule, it's going to be more of a standard repayment issue where you're just dealing with your Medicare contractor. The self-disclosure comes into play when you think that there's probably been some fraudulent activity.
Are we supposed to have every single employee read our compliance plan and then sign off that they did, or can we just train them? We had been previously told that each employee had to actually read the document.
That may, I could see somebody saying that that was a best practice. It's certainly not a requirement that they read everything. And actually, in my opinion or my real world experience dealing with compliance, if an employee has to read the entire set of policies and procedures, their eyes are going to glaze over about 10 pages into it. So I'm not sure how effective that is. I would make sure that you're training and hitting on the key points, and you certainly want to have some documentation of that training, which is probably an employee signature, saying that they received the training. But I certainly don't think, in fact, I probably wouldn't recommend that they read all of your policies and procedures word by word.
What is a good resource to reference when building a coding compliance policy?
Dr. Brooks, I don't know if your organization has something like that. There's the Healthcare Compliance Association. I imagine they probably have some products. I can't think of anything right off the top of my head that's like this is the gold standard, the go-to guidance on billing and coding, but a reputable compliance consultant, or certainly maybe a state healthcare compliance association or the National Healthcare Compliance Association. I'm sure that they have very good resources on that.
Okay, well that wraps it up for our questions. And again, Kevin's contact information is there on the screen. Please feel free to reach out to him directly, or if you reach out to us, I will send them on to him. You can register for our future webinars or request a demo of our compliance solution on our website at 1sthcc.com, or give us a call at 888-543-4778. Thank you so much for joining us, and again, thank you, Kevin.
Thank you.